your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a network and platform and meeting ground where immigrants, families, and licensed immigration attorneys engage, learn, and exchange insights on the latest developments in U.S. immigration. My name is GB Satusa, and I'll be your host for today's discussion: USCIS updates you need to know, EAD terminations, and new payment rules. In the last few months, USCIS has announced significant updates that directly affect work authorization, filing fees, and payment procedures. Many applicants are confused about how these changes impact their eligibility to work, maintain status, or continue their applications without disruption. With work permit termination notices new digital payment revolving processing times, these developments, we are joined today by attorney regionally recognized immigration attorney for her skill in removal defense, federal litigation, and appellate advocacy. She is a Crawford Attorneys at Law, Kansas City. She serves in key leadership in Lawyers Association. Her deep understanding of USCIS processes and high-stakes immigration matters makes her an ideal speaker for today's webinar. You're welcome, Attorney Crawford. Thank you so much for joining us today.
Thank you so much.
Now, before we begin, a quick reminder: Immigrate a law firm and does not provide legal advice, representation, meeting ground where individuals and families can learn about immigration topics and engage with licensed attorneys who participate independently. To our viewers, it's about to get very interesting. Grab your writing pads and pens and share the link with your friends. If you have not subscribed, now's the right time to do so. Just click the subscribe button and you're all set. Now, let's dive right into today's discussion. Attorney Crawford, could you provide a clear overview of the latest USCIS updates regarding EAD terminations, including which categories of work authorization are most affected and the timelines applicants should be aware of?
Well, sure. So, most individuals who file for EAD renewal applications on or after October 30th of this year will no longer be eligible for automatic extensions of work authorization while a new card is being processed. Now, this change does not apply to EADs automatically extended by renewal applications that were filed before October 30th of this year, nor does it affect EADs extended by law or through specific Federal Register notices, such as TPS. Before the publication of this rule, certain EAD cards were automatically extended for 540 days if the cardholder filed the application to extend the card before the current card expired. Now, with the publication of the final interim rule, this practice will end, and EAD cards automatically extended under the prior rules pursuant to the extension applications, of course, before October 30th are not affected. But these changes will automatically end extensions for certain categories, meaning that new EADs required before the current one expires to maintain work authorization without without interruption include refugees, asylees, certain parents, dependents, and children of special immigrants, certain citizens of Micronesia, Marshall Islands, and Palau, those granted withholding of removal, asylum applicants, pending adjustment of status applicants, H-4 non-immigrants, and VAWA self-petitioners. Like I said, other forms of EAD-related status, such as TPS and spouses of E and L1, may also be affected. So there's a big change now in terms of how people would wait to file for renewals of these EADs. They can't do that anymore. They really must be very mindful about the fact that if their EADs are expiring, it will interrupt their ability to continue working.
All right. So, how do the new payment rules impact filing fees, fee waivers, and premium processing? Are there any critical deadlines or changes applicants should know to avoid payment-related delays?
So as of, on August 29th of this year, USCIS announced a significant change to the payment of filing fees and service charges. As of, again, October 28th, 2025, USCIS will only accept electronic payments for paper filed applications. Now, the way that that's done is if you are making a credit card or debit card payment, you must submit along with the applications a form called a G1450. And if you're making an ACH debit from a U.S. bank account, you must also include a form G1650. Now, this is a shift from previous rules that allowed that there were paper checks or money orders. And so now the issue is that if you don't have that that form included in your application, and you send in a paper check, those applications will be rejected.
Right. So, for individuals with pending EAD applications, how might recent terminations or policy changes affect their current status and ability to work legally?
So again, as I said, the automatic extensions no longer apply. Now, for example, there are some, like for people who are on STEM OPT extensions, which were never eligible for the 540-day automatic extensions. They instead timely file your STEM OPT extension applications, which will automatically extend employment authorization documents for 180 days. So they are not going to be subjected to it. But everybody else, unless you are on TPS or an exempted category, which there are very few at this point, everyone else, I mean, the problem becomes is that you cannot be derelict. You cannot wait until the last second. You must make use of that, make sure you're filing in a timely way. Otherwise, there's going to be interruptions with employment.
Okay. So, what practical steps should employers take to ensure compliance when employees' EADs are affected or terminated under the new rules?
Yeah, it's going to create problems. It's going to create havoc. Employers are going to need to immediately, if they have not already, start to assess which employees may be affected by the new rule. They must also start processing and encouraging individuals who are within that 180 days to prioritize filing for their extensions. They should also monitor processing times. And I mean, to be honest with you, they're going to need to start preparing for gaps in labor force. That's a reality of what's going to happen. And those disruptions are unfortunately unavoidable, and I think part of the plan, to be honest. So I think employers, all they can do is make sure that they are being very actively involved in trying to identify those employees that may be impacted, and then have a plan of action as to what they're going to do should there be gaps in the labor force.
So, are there exemptions, extensions, or alternative pathways for applicants whose EADs are terminated unexpectedly? How can they protect their employment and maintain their legal status?
Yeah, I think that's the biggest problem is to plan early, because we know that there are going to be long delays. We know the processing times are also long. In some cases, they may have no choice but to try and engage the federal courts. Federal court litigation can be costly. It can be overwhelming. But again, if they're going to either have to have some kind of a plan themselves. Employees are going to have to figure out, do they have a way to sustain themselves if there is a gap in their employment, or are they going to have the resources to go into federal court and try and get their EADs, approved before there's a gap. But even federal court litigation is not fast, and so I think the only advice I have for them is to prepare for those emergencies and have a solid plan B as to what happens if they lose their job.
Right. So, what strategies or best practices would you recommend for applicants and employers to stay informed, minimize disruptions, and avoid surprises as USCIS implements these new policies?
I mean, the thing I would tell most people is that they have to be very well informed, and they need to be well informed correctly, right? If something sounds too good to be true, if somebody promises you, oh, we can jump the line, there is no line, by the way, but that we can, get you an immediate result, or we can do something that sounds way too good to be true. Check your sources. Make sure you are getting good, solid, sound advice. One thing that we know is that one of the things that comes from these kinds of desperate kind of situations where people become desperate is they rely on things that are not necessarily the best practices. They are oftentimes willing to be, spend money, time, resources buying into something that really isn't either proper, is not legal, or more importantly, is not going to get them the result that they need. So, I mean, the biggest thing that I can advise them to do is make sure that they are relying on credible information, and that they are checking their sources, and they are not just, falling for a bait and switch where they end up losing their money, losing their status, and then ending up in a situation that cannot necessarily be fixed.
Now, to everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for tuning in. Whether you are preparing to file your asylum application, awaiting your interview, or supporting a family member through the process, today's session is designed to give you clarity, structure, and confidence. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where immigrants, families, and professionals can ask immigration-related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We're also proud to share that ImmigrationQuestion.com is a BBB accredited business, reaffirming our commitment to transparency, accountability, and service to immigrant communities across the United States. Now, Attorney Crawford, with your extensive experience in criminal defense, what are your thoughts on how a platform like ImmigrationQuestion.com is helping immigrants and attorneys connect and network more effectively?
I mean, right now the big thing is that things are moving very quickly, right? And there's a lot of disruption and a lot of chaos. We, even as licensed attorneys, will oftentimes say to individuals right now, look, what we're telling you is probably valid right now. Will it change in the next 10 minutes? Yes, it absolutely could, because that's the climate that exists right now in the current administration. And so, resources that provide credible information that allow people to anticipate what's happening, are worth their weight in gold, because it allows for individuals to prevent the disaster from happening. Right? It's always more problematic to clean up a mess. I always tell people, if you don't make the mess, it's a whole better situation than if you've got a mess and now you have to go clean it up. And right now what we're seeing is that there are unprecedented enforcement activities occurring in the United States. People who are not only here undocumented, but also those who are here documented. I mean, we saw that earlier in the summer with students being thrown out of student status when their CVIS registrations were canceled overnight, and people were again having to run into federal court to deal with the chaos and the uncertainty. So in that way, I think right now the best thing people can do is be proactive and be actively involved in the preservation of their immigration status. That doesn't mean that, if you're talking about, can I land in deportation proceedings? Yeah, you may land in deportation proceedings, but the time to find out about that and to plan for that is before you land in deportation proceedings, right? There's a number of steps that the current administration has taken that have made simple arrests now cause people to be mandatorily detained. They are denying bond on record levels. They are detaining people in records of it. This is all scary stuff. People don't want to necessarily think about this. And the problem is that by not thinking about it, you place yourself in a much more vulnerable position than if you are actively working to understand where the pitfalls are, where those issues are, where you may find yourself in sideways with whatever's going on. And it's not even people who are undocumented. We're seeing time and again, it's citizens, it's green card holders, it's people who are here lawfully who are finding themselves trying to convince ICE that they are here lawfully. So those are all things that, people can take active steps on and have a plan as to what happens if you are confronted by ICE, what happens if you are taken into custody, how do you get out of custody, what happens if, you find yourself unable to prove something. I mean, they're going after people to denaturalize individuals, people who are citizens, right? You want to have a plan, because I think under the current climate, it is better to understand that there's no one that is safe. And I don't say that to scare people. I really don't. I say that to encourage people to get information.
Thank you for that perspective, Attorney Crawford. Before we move into our live Q&A, let's explore one more critical issue. What key strategies would you recommend for applicants who want to stay organized, track their case progress, and prepare effectively for changes to EAD processing or payment procedures?
Well, I mean, I oftentimes meet with people and I'll say, do you have a copy of your application? No. Why not? Do you know what's going on with your case? No. Why not? I mean, it's no different than, if you went to a doctor to seek out medical advice. You're not just going to say, well, I'm going to blindly do what the doctor does. I don't know what pill they're telling me to take, but I'm going to take it anyways. You would never do that. And I think sometimes individuals don't ask or take an active role in their own case. You've got to know what your status is. You've got to know what you filed. You've got to know when you filed it. You've got to know what's in the application, right? All too often, they're like, oh, I don't know. I told the lawyer and the lawyer wrote it down and then I left. Why would you do that? You would not do that in any reasonable way, because your name is the one that's signed on the application under a penalty of perjury. So in that way, you are saying everything in the application is true to the best of my knowledge. And if you're not doing that, then the problem becomes is that, if you don't know what's in the application and you're later confronted with, well, why does this say that you came and went from the United States, or you filed an application and said you were married when you weren't, or you said you had 4 kids, but you have no kids. Those are material misrepresentations. And unfortunately, it's not going to be the lawyer that's going to have to go in and say, oh yeah, I just put that down. They're never going to say that. Or, oh, I went into my friend's basement and my friend filled it out. You wouldn't go get your teeth pulled in somebody's basement. Why are you letting someone do forms in someone's basement, right? So I think those are the things that I would recommend is be very reasonable and diligent. And if you wouldn't do that with your health, with your well-being. Consider this the same. Would you make these choices if this was about your health and well-being? No. Would you do this about your legal case? Well, yeah, I was too scared to think about it. I mean, there are some medical conditions that are scary, but you still look at it and you still understand it, right? So it's the same kind of thing is have copies of your file, have copies of your information, know what it is that you've signed, understand when and where and how you filed something. All of those things become very important, and really somebody's future in the United States may depend on that.
If you've just joined us, we've been in an insightful discussion with Attorney Rekha Crawford on USCIS updates you need to know, EAD terminations, and new payment rules. We're now moving into our live case session. This is your opportunity to ask your questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483, and we'll take as many as possible during this session. Right, our first question. Please, if my EAD ends because of parole termination, can I ask USCIS to fix or appeal?
Say that again.
Please, if my EAD ends because of parole termination, can I ask USCIS to fix or appeal?
I'm not fully understanding the question. I mean, if the EAD ends, there's nothing for USCIS to fix or appeal.
All right.
So I guess the answer to that is no, because there's no authority for them to fix anything, or there's nothing to appeal, right? I mean, if the parole has ended and the parole is terminated, then at that point, the EAD that was associated with it is also terminated. And USCIS is going to say, we're taking orders from higher up, so there is nothing to fix or appeal.
All right. Let's have our next question. If I mail the wrong fee, will USCIS reject my paper or give me a chance to fix it?
Yeah, they will send it back. They will reject the filing as improperly filed. Now, of course, there's issues with that, right? Because one thing that we have noticed is that USCIS doesn't act very efficiently, in the sense that they don't always go in and like, it's not when you file it and then you get a receipt right away or a rejection right away. There may be a lag of months before you get that application sent back to you. Now, does that cause even further delay? Does it cause a gap in your status, right? Those are all things that you want to be mindful of. So that's why we say is that you want to file as soon as you are eligible to file. So that way, even if it's rejected a month later, you're not having to deal with any gaps.
All right. Are employers notified when EADs are terminated for a group?
They're not notified by USCIS, meaning that USCIS doesn't send anything to your employer. They don't know who you work for. But the issue is that the employers are required to, under law, to be making sure that those individuals who are working for them are equipped and authorized to work. And so even if USCIS is not sending them a letter, the chances that the employer will find out that the EAD has expired is very high.
All right. USCIS require a new HR1 fee, but I have a fee waiver before. Can they still make me pay?
Yes, the fees. I mean, arguably at this point, what we are seeing on the ground is that the waivers are all being denied. So you can, even if you had one before, it doesn't mean you'll have one in the future. And even if you file one, it certainly doesn't mean it'll get approved.
Can I still pay USCIS fees by check or money order?
No. At this point, we are past the date of enforcement, and so no.
Right.
Which is arguably one of the concerns people have is what happens if you aren't able to pay with a credit card or don't have an ACH. But again, I'm of the opinion that's part of their plan.
All right. What steps can I take now if EAD termination or new fees affect me so that I don't lose my job or status?
As I said in the conversation earlier, I mean, you have to be able to understand that. I mean, the fact of the matter is file for your extension or your renewal as early as you can, but understand you may end up losing your job if you are looking at a long processing time, and then federal court litigation becomes your only hope. Although, again, if you just filed yesterday and now you want to run into federal court and say, Judge, help me, they're going to say, well, why did you wait 179 days to file?
All right, so that was our last question. So, Attorney Crawford, let's digress a little as we wrap up. A new Trump directive is expanding visa denials based on health conditions and financial status. How do you see this affecting applicants who have ongoing medical needs or limited financial resources?
Well, I mean, I think, part of the administration's plan has been not only a crackdown on undocumented individuals in the United States, but I think there's also a concerted effort to crack down on legal immigration. We see that in the record number of low number of asylees who are being allowed into the United States, and refugees who are being allowed into the United States. They're at record low levels. So I think this is just another push in terms of the health conditions that they're looking at. Is there any kind of chronic health condition that would cause somebody to have financial burdens as a result of that health condition? They do that all the while they're cutting back on insurance coverages for so many. So, I mean, again, I think when you look at this from a greater perspective, what you realize is that these are all obstacles put in place in an effort to try and crack down on not only unlawful immigration, but also legal immigration. So I think those are going to be issues in terms of if you're appearing for an interview at a consulate, to be able to show that you have the financial ability, that if you have a medical condition, that is something that you are working on and you have the financial resources to address. Some of the sad things about that whole thing, though, is that it includes things like diabetes, heart disease, obesity, mental health disorders. I mean, things that, historically are not considered communicable diseases, which is really what the law was designed to address. With regards to financial issues, I mean, we saw this during the first Trump administration, where the public charge issue was such heavily litigated because they were putting so many barriers up for people who could enter the United States. This is just a continuation of the same.
Thank you so much, Attorney Crawford, for your time, expertise, and clarity today. Your insights have given applicants the direction, awareness, and preparation they need to navigate these new USCIS rules confidently. And to all our viewers, thank you for joining this meaningful conversation. We hope today's webinar helps you stay informed, organized, and prepared as you work through your immigration process. Remember, you can always visit immigrationquestion.com to ask your immigration questions free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's webinar or share it with others, the full replay will be available on Spotify shortly. Search for Borderless Talk by immigrationquestion.com. Join us again on Friday for another live session exploring key immigration topics, including family petitions, humanitarian relief, employment visas, compliance strategies, and others. Once again, thank you, Attorney Rekha Crawford, and thank you to everyone watching. Until next time, stay informed, stay prepared, and stay connected.
Thank you.